afternoon and a very warm welcome to this AIBC panel discussion. My name is Satyarth Mishra and I am the AIBC National Digital Advisor, also the CEO of DigiRuption, which is an independent digital transformation advisory and consulting firm. Before we begin the proceedings, I begin by acknowledging the traditional custodians of the land on which we meet today, and I wish to pay my respects to their elders, past and present. We have a very exciting panel discussion today, which is eminently topical as well. But before we jump into it and commence proceedings, may I take this opportunity to set the context of where the Indian IT industry is globally and also in the Australian construct. Indian IT industry turns over $195 billion every year, employs 4.5 million people. From an Aussie perspective, Indian industry set its foot in Australia 30 years ago, and since then has evolved with the Australian digital economy the way we see it today. 60 to 65% of the Australian Indian IT company, I beg your pardon, 60 to 65% of the workforce of these companies are local nationals. This is quite a significant number and stands to exponentially increase in the times to come. Coming to the discourse that we've planned today, DLA Pipers have very kindly agreed to sponsor and conduct this highly topical panel discussion. The theme happens to be the new ATO Draft software ruling. This is a critical ruling. It's still in its draft stage, and it will have far-reaching implications for both the Australian and Indian economies. Being a part of AIBC, which has fostered, nurtured, and promoted bilateral commerce and trade between the two great countries over 35 years, our objective today is to commence the dialogue and take it to a symbiotic outcome. That said, may I now invite Jock McCormack. Jock is my co-host for the session today. Jock is a partner and also the head of Australian tax practice at DLA Piper. Without further ado, Jock, may I hand over the forum to yourself? Thank you.
Many thanks, Satyarth. And on behalf of DLA Piper, it's a great pleasure to co-host and work with the Australia-India Business Council on this really topical and critical ruling and the whole area of software licensing and distribution and related matters, and most particularly the ATO draft ruling that we are going to talk mostly about. While it's important to note that the COVID environment, if you could go to the next slide, please. While it's important to note that the COVID environment's been very disruptive for business, it has also been disruptive for the ATO, and through the course of it, a lot of ATO executives were seconded to the economic and stimulus initiatives run by the government. However, please be very aware that all or most of those executives have returned to their normal day jobs in the ATO and are very focused on audit activities and most particularly issuing guidance like this draft ruling that issued several weeks ago. So the next point to be aware of is that consistent with this ruling, there are a lot of other international tax developments that you should be mindful of in addressing it. Firstly, the Australia-India double tax treaty has been modified by the multilateral instrument, effective basically from 2020, and there's some important issues that we'll highlight around that. Clearly, pillars 1 and 2 that are evolving internationally. Australia and India have been very actively involved in the whole process, and certainly Australia is very supportive of the directions of pillars 1 and 2. Finally, in terms of transfer pricing, continues to be a major focus, as evidenced by the recent Glencore case here in Australia. And associated with that, there's the other guidance that you need to be aware of is this practical compliance guideline 2021 D4, which deals with the whole range of issues affecting intangible assets. Next slide, please. So the format and agenda for today's session is very much, although we focus on the draft ruling, it is important to set the scene and revisit some of the key aspects of the Tech Mahindra decisions of a couple of years ago. And we're delighted to have Vishwanath, who was integral and heavily involved in those. And Paul and he will lead us through, a discussion on what the key outcomes of those decisions were and as they impact on the draft ruling. The draft ruling, they will analyse very closely and not just practical consequences, but where they think it's headed through the further consultation process, and hopefully with a view to finalisation as a very useful guide, not just for the revenue authorities, but also for taxpayers and international taxpayers. The treaty issues I've mentioned and other ATO guidance. We will then have several minutes for Q&A. We've already had some very good questions tabled, and we'll go through those and then the session will close. So it is my great pleasure now to hand over and introduce very briefly, although you have their CVs, firstly my dear colleague, partner, Paul McNabb, who joined us about 15 months ago. Paul is a leading international tax disputes and controversy partner. He's a high-level specialist in the technology sector and will share a lot of his very dear expertise and experience with us today. And secondly, and most importantly, we're delighted to have Vishwanath Kinney, who is Vice President, but also Global Head of Tax for Tech Mahindra, one of India's largest companies, and has been very heavily involved, not just over the last 14 years with Tech Mahindra, but has a wealth of experience and expertise from his long career with various IT companies, multinational IT companies. Without further ado, it's my great pleasure to hand over to Paul to start the more detailed dialogue on the ruling.
Thanks very much, Jock. So if we could go to the first Tech Mahindra slide, please. Brilliant. So I guess, the Tech Mahindra decisions were some years ago, but I think it's terribly important, as Jock said, that we spend a little time going back to have a look at those for two reasons. Firstly, the reason Jock mentioned, which is that when we look at the mechanics of that decision and the sort of business models that it covers, we prepare ourselves to then look at the changes the tax office is proposing in the draft ruling. And we have an opportunity to ask the question for people who lived through Tech Mahindra, who understood the consequences, does the draft royalty ruling actually require them to think differently about the businesses going forward? And the answer to that is that the Tech Mahindra decision is typically a decision which is focused on because of what it tells us about how the treaties work. But there's also a really important part of the decision in the Court of First Instance, in the 2015 Federal Court decision, where the court spends quite a bit of time discussing each of the service offerings in question, and then comes to a landing on whether or not those particular items are royalties or not. And of course, that's a very clear link back to the draft ruling that we're going to be talking about at the end, which itself goes through a number of business model examples, a number of service offering examples, and asks exactly that question. Is this particular fact pattern going to give rise to a royalty? The one thing I will say at the start, and which will become apparent as we start going through this, is that the answer to that question depends incredibly on the facts. So disputes about royalties and tax disputes generally really are fact-driven, and it's difficult to discuss these topics and to give examples that apply widely to a large number of taxpayers. But nonetheless, that's what the ruling tries to do and what we'll try to do in our discussion today. Of course, the enormous privilege we have with Vishwanath's presence is the opportunity to actually not just see what the judgments tell us about these cases, but also to understand some of the practical problems that taxpayers face as they try to work through this stuff. So that's broadly the significance of going to Tech Mahindra first and then coming back to the ruling afterwards. So just initially, what I wanted to do was just focus on the key conclusion of the decision itself, which I've got up on the slide there. If an Indian entity performs services in India and the payments fall within the definition of royalty in the treaty for an using the Australian rules. Now, that's an incredibly simple example or discussion, and yet you can see you've got two very significant judgments and a High Court leave application hearing as well, all dealing with precisely this question. So it's not as simple as it looks is the very key example. When you have a look at the bottom of the slide, though, there's a couple of observations. One is that the Indian treaty is relatively unique. So the tax office ruling, the draft ruling, doesn't talk about the interaction of the discussion there, the royalty discussion there, with the OECD commentary and the broad OECD treaty principles. So you always have to remember that each treaty is unique. This particular one is extremely unique. And the discussion we're having today is very much focused on the consequences for Indian companies because of the peculiarity of that particular treaty. If we could just go to the next slide, please. And this picks up the observation in the previous slide that the question of the real turning point in Tech Mahindra is the conclusion that if a particular transaction falls within the definition of royalty, then it's Article 23 that goes on to say that this is then income of the foreign company sourced in Australia and which may be taxed there. So a fairly straightforward application of Article 23 at the end of three court hearings. Could we go to the next slide, please? So, and this is the part of the single judge in the federal court decision that I wanted to really focus on. So we think about Tech Mahindra as very much a decision talking about the question of how the treaty interacts with domestic law, how the transactions then flow into the Australian tax base to be taxed as ordinary income. And this part of the federal court decision is the part that really is worth reviewing again now that we're looking at the draft ruling, because there were 9 different categories of services identified by the court, and the court works through each of those categories in detail before deciding whether or not the payments in relation to those categories are a royalty or not. And you can see them there. You can see that really the only 2 that were definitely not viewed by the court as giving rise to a royalty were maintenance and problem solving involving no change to the source code. Quite a lot of the other work that was being done, and which that decision dealt with around the development of software, the customization of software, and the alteration of it, the bug fixing in it, the development of enhancement for it. Many of these things gave rise to royalty payments within the treaty definition. And also there were a number of services that were said to be related to or ancillary to those services in a way that brought them within the broader definition of amounts deemed to be a royalty because they were connected with a royalty. So an extremely important analysis. What is important to remember, though, is that all of that analysis drives off the definition of royalty, and in the case of the Indian treaty, what it does is to take the part of the definition of royalty which we're all familiar with, and then add to it a category in relation to certain other services which are also deemed to fall within that definition. But because the starting point is the definition of royalty that we all have, then we can see that when the tax office comments on that in the draft ruling, what the tax office is doing is giving us some guidance as to whether or not these basic categories in Tech Mahindra might or might not be extended by the new thinking that we'll see emerging in the tax office draft ruling. The thing that always struck me about this is the enormous amount of work that must have been associated with the analysis of revenue and activities. And I guess I wanted to turn to you, Vishwanath, and just ask for your observation on how difficult the task of just taking the company's operations and contracts and categorizing them in this way for the court case. Just how practical a problem is that going to be for a lot of taxpayers? Would you be able to give us some observations?
Sure. Thanks, Paul. So I think before I come to this particular point, I think the fundamental difficulty what I think we faced in this decision, which I think was covered in the order, is we were saying there was some service which was done in India and there was some service which was done in Australia. What was actually required to be done is what was actually attributable to that permanent establishment in Australia, which should have been subjected to tax. The services what was rendered in India could not have actually fallen into the category of Article 7 for any of the services to be taxed in Australia. Now, having said that, they have completely deviated from the fundamental principle of Article 7, and they have moved to Article 12.3G. Now, yes, Paul, I think the analysis of 12.3G was something, it was not expected when this particular, discussions were happening at the courts, and I think they did give us time to do the analysis. It was a very laborious one, because generally what happens is in a typical purchase order or an MSA or a master service agreement, what we sign with the customer, they would generally tell us you have to do an end-to-end software development service, or they would say you'll have to do some maintenance or you'll do some bug fixing, etc. This could be number of purchase orders or work orders. Now, in a typical transaction where a customer tells us that you will have to do an end-to-end service, we at the front ending this particular case before the tax officer are completely not aware of how this categorization can be done. So what we generally do is we go back to our technical teams and we ask them that how do you categorize this type of service into these 9 categories? Now, development, customization, maintenance. Now, it is it becomes very subjective for that particular technical guy to categorize in that particular manner. Either he has to go based on a timesheet or the type of work, because generally when we do this exercise, it's already we are almost 4 or 5 years have lapsed since the time this activity would have got undertaken. And in fact, in our case, it was a 7-8 where we were doing it somewhere in 2014, 15 or so. So it was almost 6 years, 7 years elapsed. the people who had done this activity would have either left the organization or may not remember, even if they're there in the organization, may not remember that this is how the whole thing was done for a particular customer. So it was, as you rightly mentioned, it was going to be a Herculean task for any organization or any industry to do this categorization in the manner in which it is defined through the court order. And we should be mindful of this fact that this particular categorization was done only for 3 customers when the case was going on. And since after 7 or 8 years had lapsed, I think Satyam, it was actually a Satyam case and it got merged with Tech Mahindra. We would have had some 15 or 20 customers or much more than that. And we really don't know how each and every type of service, the offshore service, what is being rendered to a customer in Australia can forcibly fitted into this 9 categories. I think that's the biggest difficulty what each industry would have faced.
So the 9 categories, though, were categories that the tax office and Satyan's lawyers agreed on as a sensible way to break up the activities that were undertaken by the group. They're not strict royalty categories within the treaty definition, are they? So there's an extra layer of analysis anyway over the top of it all. This makes sense from a business point of view to say these are the 9 categories, but you then have to say, okay, how do I translate that into the treaty definition of royalty?
Absolutely. Yeah, because as I mentioned, there were only 3 customers and the categorization, we had to do it only for those 3 customers. Yeah. So over the period that things got evolved, there were new contracts, new type of activities. So I think it was an evolving process year on year, which I don't think any industry would be able to fit everything into the 9 categories. Yeah.
No. And can I ask, because it will become an important point later when we get to the tax office ruling, even within the categories, you're dealing with an overall contract. So you've still got the practical problem, I suspect, of then trying to decide out of the entire contract price, which amounts are allocated to each of these activities. How difficult was that thought process?
So as I mentioned, it would be based on a particular purchase order or a work order. Suppose if the work order value is, say, let's take for argument's sake, 500,000, I would give to a delivery head who would have performed that particular type of service to a customer in Australia. And it could be subjective or it could be judgmental, that out of that, some portion of value of 500,000, maybe 100,000 will fall in 1 or 2 or 7 or whatever it is. So it becomes slightly subjective, or I'm not too sure, we would have had maintained the timesheets or the type of work what we would have actually performed to that customer. So those are the difficulties what any company would face at the time of categorization and putting a value there. Yeah.
And I assume that then flows into future problems. Now that you know this is an exercise that's required, there's a practical issue around what systems can you put in place to make the task less painful in future years if the business structure remains the same and the issue remains the same. There's a practical problem for the future as well, I suspect.
Absolutely. As I mentioned, it's an evolving, information technology is an evolving thing, right, year after year. So we might get into cloud computing, we might do a lot of business process outsourcing. I think none of these type of services are ever defined in the 9 categories. So I think that's where all these difficulties are going to be faced by many of the IT companies.
Which I think is another point we'll come back to when we have a look at the draft ruling itself. Could we have the next slide, please? There are 3 slides now, and I just want to look at 3 different business models that Indian companies have used in doing business with Australia. And the reason for this is because as I say, the Tech Mahindra decision is based upon the very particular facts of that group at that time. The structure used, and these structures arise naturally because of different characteristics in the organisation. There were other structures. It's important to understand what some of those look like, and even these 3 don't represent all of the business structures that might have operated. But what these 3 do, I think, is point to a couple of the other issues, the structural issues that we'll see when we come to the tax office ruling at the end. So this slide is a very simple representation of the Tech Mahindra decision, business structure, the decision actually looked at. There's a couple of key points, one of which Vishwanath focused on, that I just want to mention. One of them is that you have an Indian supplier and Australian customers, but the Indian group does not have a separate Australian legal entity. Although there are some activities being performed in Australia, there are also activities being performed in India. And those of you who work with treaty concepts will recognise the problem that Vishwanath described, which is that the treaty really separates the treatment of royalties from the treatment of business profits that are attributable to an Australian business permanent establishment. So if the enterprise had an Australian permanent establishment and the services that occurred in India were said to be attributable to that permanent establishment, were connected with it, then I think you may have got a different outcome in the matter. And you may have also got a different outcome if the Australian operation was a separate corporate entity, depending on a whole host of other factors. But so that's the basic structure we start with Tech Mahindra. If we could go to the next slide then, please. So in some cases in the industry, we see an Australian subsidiary in place, and it's the Australian subsidiary that contracts with the Australian customer. So here you have a situation where the Australian subsidiary could do several things in response. The first thing that could happen is that the Australian subsidiary could effectively resell the services of the Indian head company. In other words, the Australian subsidiary becomes the sole principal and contracting party with the Australian customer. The alternative is that the Australian subsidiary treats the Indian head company as a subcontractor, and there's a delivery of services from the head company to the Australian customer, so that the payments by the Australian subsidiary to the Indian head company, the characterisation of those payments may be different depending on the terms of the agreement between the head company and the subsidiary. But again, a different fact pattern to Tech Mahindra, a change in the nature of the contracting party, a change in the way the invoices flow, and potentially a change into a very clear and quite different relationship between the Indian head company and the Australian subsidiary. In this structure, and as we'll see when we get to the tax office ruling, it's the intercompany service fee between the Indian head company and the Australian subsidiary that will come into focus as we look at the Australian draft ruling. Could we have the next slide, please? In this case, what I've tried to demonstrate is a slightly different fact pattern to Tech Mahindra. There is an Australian permanent establishment, but this is a situation in which the services being offered are all inextricably linked to the operation of the Australian permanent establishment in a way that attracts the business profits article of the treaty, and the proper allocation of tax obligations between the head company and the permanent establishment now becomes an exercise under the transfer pricing rules in the tax system. So instead of the treaty article giving the Indian company Australian sourced income and taxing it using the ordinary income tax rules, here we have a situation where potentially the question of how much profit is taxed is a classic transfer pricing issue of determining the appropriate profit allocation to all of the activities that are associated with the Australian permanent establishment now. So again, just wanted to set those three up before we turn to the draft ruling itself. Could I then have the first slide on TR21B4? Thank you. This, as I say, this is a document that comments are invited on, and the closure time for comments is fairly much here. most organisations who have an interest in this or involved will have already drafted submissions. To the extent that this material is problematic and you haven't, though, the tax office generally will take into account comments lodged after the commentary date, if they're sufficiently important. So I wouldn't be deterred by the date, but it's worth noting that it's arrived. It's also important to understand that the last public ruling on this topic was 1993. So that's quite extraordinary when you think about it. The technology sector and the nature of services delivered has changed a lot since 1993 to 2021. And yet you can see that this is the time period between updates. In a way, it's actually a tribute to the value of TR 9312, which for its time was extremely well written. It was principles based, so it gave approaches to use rather than being prescriptive about how different transactions had to be treated. So it became quite a useful document. And I think the fact that it's taken so long for an update to occur is actually a tribute to the quality of the work on TR 93 back in the day. However, there have been a couple of attempts at the rewrite. The rewrite's been going on since around about 2018, 2017. There was an earlier attempt to capture some of the business models that the tax office felt were no longer properly addressed by TR 93. That exercise ended without the production of a ruling, as it became apparent that the examples didn't have quite the right level of detail, and it was really 21 before we started to see the new version, which has turned into TR 21. There have already been a number of submissions made on the draft ruling in the various earlier phases. I've tried to capture a couple of them there below, and I suspect Vishwanath may have other issues that he thinks need to be hopefully addressed as well. But the first problem, tax rulings by themselves, if followed by a taxpayer faithfully, if relied on by a taxpayer, should prevent penalties. And the initial draft of this new ruling suggested that its application would be retrospective, and that caused quite a deal of submissions from the profession, saying that it's difficult to, it's impossible actually to overrule a ruling retrospectively. What you can do is change practice from a certain date prospectively. And the final version of TR 21D4 actually has a carve out that says that if a taxpayer has relied on the earlier version, on the old TR 9312, then they're entitled to that reliance during the period they did so, but we'll have to take account of the new ruling going forward. I think the thing that stood 9312 in tremendous stead was the fact that both it and the OECD very much used a substance over form, not form over substance approach. So instead of saying all agreements that look like this produce this for a transaction that is inoffensive. So substance over form is very much the approach. One of the complications is with the new TR 2021 D4 is that some of the examples appear to be more form-based than substance-based. You simply see an evolution of a particular business model into a new technology base, but you get a different treatment because of the change in technology base you're using, which many commentators think is probably not what you would be hoping to see in an area like this. So there's a question around substance over form. There's also the fact that 2021 D4 is very much domestically focused. So it focuses on the concepts as they exist in Australia without addressing things like the interaction of the international agreements, the OECD commentary on it, which is something that was, I think, more fully explored in TR 9312. So another area where I think there's the possibility of some improvement. One of the other observations is that there is a particular practical problem which Vishwanath very much alluded to, which is it's rare to simply have clear discrete payments that are royalties. It's most commonly the case that you'll have a very complex agreement delivering a whole bundle of services, a whole of life project of some sort, where some elements of it might be said to be a royalty, and where the parties are left trying to figure out how to apportion that. So practical guidance on how to do that would be useful. There's quite a body of tax office publications dealing with how to resolve practical apportionment type disputes. The tax office very much embraced the process of alternate dispute resolution, the proper use of experts to decide factual issues like this, or to help courts decide them, or to help the parties negotiate an outcome based on expert input around things like valuations and apportionments. So there's quite a body of material that taxpayers will still have recourse to as they look at some of these problems, but in a sense, it often won't make it a lot easier unless, as Vishwanath discussed, you think forward and put in place systems that give you the information you need at the very start. So some interesting changes in that. What I wanted to do then, if we could go to the next slide, please, is just to have a look at some of the particular comments in the new ruling. So what the new ruling does is, by way of examples in Annex 0A, give examples of fact patterns and then give an analysis of how the tax office thinks through the particular example, the fact pattern, and the answer that they believe comes out of it. And this slide and the one that follows, I think, from memory, and the one after that, they're really just designed to give at a very high level a sense of what those examples look like. So, and some of them, to be fair, are very much an acceptance of the position in 9312. And I think towards the end, I'll come back to two examples which I think represent new insights into tax office thinking in this area, which have to be very carefully studied, particularly for those business examples we talked about earlier. So a simple license to reproduce software is a royalty. The fact is that in all of these examples, the thought process that the tax office is using is to ask the question, what is the activity that's permitted? And is it an activity that would ordinarily be reserved to the owner of the intellectual property rights? So if software is a copyright article, then only the copyright owner has a capacity to reproduce it, reproduction being one of the principal rights of copyright law, and therefore payments for permission to reproduce are a royalty. So a fairly straightforward example, very consistent with 9312. A license to modify software, including access to source code, is very much, in the tax office view, within the definition of royalty relating to the provision of commercial, scientific, or industrial information. So this is giving access to proprietary knowledge or information which enables a party to actually modify the underlying source code, and that will fall within that limit of the definition of royalty. On the other hand, a license of simple use of software is not a royalty, because it's said that this merely confers the minimum rights necessary to enable a user of software to practically operate it. Example 4 is important because here we're dealing with a situation where there is a distribution agreement and the distributor ends up with rights to enter into end user license agreements. Now, if we think back to the second example that we had in the business models that we looked at earlier, where there was an Australian subsidiary, this is the critical example where we see a new thought process in the tax office analysis, and where we come to an area that is not dealt with in 9312 and which has to be very carefully looked at in the business models we put up on that earlier slide, but also has wide application to a lot of business models. Because here we have potentially a situation where you have an Indian parent, an Australian subsidiary, and the Australian subsidiary is entering into agreements with customers whereby the customer is being given new software as a result of that agreement. So the Australian subsidiary is a distributor. It has a power to enter into end user license agreements. And working backwards, these are activities that ordinarily would be reserved to the copyright owner. Now, it doesn't matter in the tax office's thought process that the intercompany agreement between India and Australia, between the two group members, it doesn't matter that that distribution agreement doesn't say we grant you access to the copyright. What the tax office analytical process does is it says, start at the end, look at the Australian subsidiary, the Australian customer, and the end user license agreement that now exists between them, and ask yourself, what rights did the Australian subsidiary have to have, either express or implied, to be able to do that legally? And the answer is, it must have had some of the rights of the copyright holder. Therefore, some of the payments by Australia to India must be in relation to that right and must be royalty. If the agreement doesn't expressly state, we grant the rights necessary for you to do this, and doesn't expressly attach an appropriate dollar figure to them, then you're left with a situation where that contract payment has to be analysed, apportioned and valued to determine which part of it relates to the actual rights that give rise to the copyright. Because of course there are probably a whole lot of other things going on between the parties here, and it's not a simple case of all of the payment being a copyright. So just to go back to Tech Mahindra, this is not a problem that arose on the Tech Mahindra decision, on the facts in that decision, but it's a problem that becomes apparent when you take the slightly different business model that taxpayers may have used, thinking that it doesn't have a Tech Mahindra issue. And now we see the tax office saying, sure, but that business model may have other issues that we now highlight in this draft ruling. So to me, this is example 4 is incredibly important, and anywhere where a business model has an end user license agreement between Australian customer and Australian subsidiary is a business model that needs to be looked at carefully under this ruling. Could we have a look at the next slide? Thank you. Example number 5 is the other example, which to me shows new thinking by the tax office and is incredibly important. So to Vishwanath's point, business models evolve from simple delivery of software in a box to delivery of software over server downloads with a license key to potentially software as a service models, as we see in 5, where in fact the software, most of it potentially not even delivered to the client. The client is actually accessing a cloud-based server where the bulk of the code resides and where the applications are used in a system that is not their own. What is interesting about this example is it again focuses on what it is that the Australian subsidiary is doing and the relationship to the customer. And it says, well, the Australian subsidiary is entering into agreements with a customer, and the terms of those agreements make it clear to us that the Australian subsidiary must have had either direct or implied rights in relation to the intellectual property to make that possible. So therefore, some part of the payment must be a royalty. And again, the fact pattern in the example is quite complex, but the basic concept is the same. Start with the bottom and work backwards. Start with the Australian customer, the entities dealing with the customer, the terms of that agreement, the behaviour that it allows, and use that information to decide whether or not some part of the payment going offshore is a royalty, regardless of what the intercompany agreement says. Start with the end and work backwards. So quite an important insight into the way the tax office thinks about these problems. Software distribution not conferring copyright, not a royalty. Services ancillary to the modification of software, potentially a royalty. And services ancillary to simple use of software, not a royalty. These other examples, I think, are pretty consistent with 9312 and really carry forward the analysis that was there. So, I guess, Vishwanath, I wouldn't mind just coming back to hear your reaction to the sorts of models that you see here in these examples, and perhaps your thoughts on how consistent this is with the royalty analysis that we see in the Tech Mahindra decisions, and also possibly whether you see any practical problems with the way the ruling addresses the subject and topics that you think might be difficult for taxpayers to manage.
Yeah, I think thanks, Debo. So I think, as I mentioned in the beginning, the decision was actually hinging on only some 3 or 4 contracts of a company which actually got merged with Tech Mahindra. So that's a limiting factor. It doesn't encompass the entire, you can't say that everything got covered in that particular decision. So that is one differentiator. The second is, over the years, I think each of the IT companies have got evolved, and the number of service offerings what the companies have been doing. I mean, there's a cloud computing, there is some AIs, machine learning, there is a BPS, there's a business process outsourcing type of model, which many of the companies are undertaking. And I think over the years, I think this has undergone a significant change. And I think I'm not too sure whether this particular ruling tries to capture each and every type of service offering which an IT industry would be doing for a client. Coming to that example, Paul, on the subsidiary model, I am not too sure how that would actually be. I hope it doesn't get into another litigation situation, because this particular model, what we had encountered was typically a branch model or a permanent establishment. So in a typical subsidiary model, I mean, there are situations where there are some transfer pricing issues which many of the companies having such models have been facing. So I'm not too sure whether that could could be an answer to many of these points what I think is coming out from the ruling. So that is the second concern. So I think there were discussions where we were trying, or we were being advised that would a forming of a subsidiary in Australia would be something what you can see that you may not fall into the category of royalty. But I'm not too sure whether that will solve all the type of problems what the IT industry would face. So I think, as I mentioned, the industry is evolving, and I think it's evolving by every an hour, I would say. I mean, IT industry, as I think Satyarth in the beginning mentioned, India contributes almost like $250 billion of revenue. And it's one of the largest source of revenue for an Indian government. So I think that's where the concerns are for the IT company, especially in the ruling part also.
So I think it feels to me as though the sort of evolution that you're talking about, though, is going to be terribly difficult it's almost impossible to maintain a ruling that deals with new situations as they occur. You'd be permanently working behind, trying to play catch up with the ruling, I think.
Absolutely. So even even if you have read that particular decision of Tech Mahindra, I mean, the fundamental point what they have been raising is whether a type of service has touched the source code or not, right? That's where I think they were saying, yeah, if it has done something with the source code, then yes, it is royalty. Now, even if you see the type of categories, let's take a case of consulting, right? Now, even all consultant companies are also doing a lot of consultancy. We do consultancy for customers. Where is the touching? I mean, where do we really touch the source code? Now, there also they have said partial, it's royalties. I don't think consultancy, they have said, okay, if it is consultancy, it will be kept outside. So I think I'm not too sure whether, according to me, that's my personal view, I'm not too sure whether this decision of ours or the ruling what has been planned for the future covers all the aspects of a typical IT company which provides the service. I think that's going to be a challenge, and I hope and I really pray that a straightforward case of a Tech Mahindra or any IT company which got into so much of litigation, I hope the ruling doesn't entail any further, litigation, more litigation, instead of really having a solution to the entire, type of service what we are providing. Yeah. I think that could be the fear for many of the IT companies. Yeah.
I think one observation is that, of course, the ruling system is mostly used by taxpayers as a shield rather than a sword. So it tends to be the case that if you fit within the fact pattern of a ruling and you're comfortable with the treatment proposed, then the ruling gives you some comfort around how it operates. But I can imagine that taxpayers who face uncertainty about the ruling or who feel the situation is simply not dealt with within the ruling because of their business model or the nature of their contracts will face a difficult choice around whether they form their own view, to what extent they engage with the tax office around the issue in advance. Do they seek a private ruling? It becomes a management of risk, I think, for individual companies. But I think to me, the really clear message coming out of your concerns is the value of, as much as possible, a principles-based analysis in the ruling, and the examples are merely some current thoughts rather than a definitive statement on all the possible situations. So again, as I said earlier, I think if it was a principles-based approach, you would expect that it would be more substance over form. You would see less distinction on things like, is there a subsidiary or not? The question is there software distribution? Is it, and is the treatment of software distribution broadly consistent, whether or not there's a subsidiary or a permanent establishment or some other model? So I can see that there's a risk that some of the approaches here could lead to more disputes, unfortunately. I think then if we could just flip over to the next slide, please. These were just a couple of quick observations on the difference between 93 and the current one. I think I've already discussed briefly the fact that there seems to be room for more interaction with the international agreements framework. It's also interesting to compare the practical difficulties you faced in court in Tech Mahindra in categorization, the approach taken with the 8 examples in the ruling. There's not a complete easy mesh up between those two, even though Tech Mahindra to some extent I think is one of the most complete Australian court cases where somebody's tried to analyse the operation of the definition of royalty on businesses. And I think clearly the main point in those 2 examples I spoke about is effectively sub-license or other end user agreements. Could we just flip to the next slide, please? And again, the focus to me is very much on these 2 examples, 4 and 5. Just 2 observations at the end. One is, I think, as I say, go to the end agreements, go to the behaviour of the in-country entities, work through that carefully, and then ignore what the intercompany agreement actually says and ask yourself, what does it imply between the parties? I think that's a really important question. The last observation I would make is, sometimes fixing these problems or fixing a risk can itself create new risks. Wholesale changes to intercompany agreements to fix a royalty withholding risk also have to work through the general anti-avoidance rules, DPT, and the other Australian provisions. You shouldn't simply change these things without quite a lot of care. They're really the points I had. Vishwanath, did you have any other observations on this entire subject?
No, nothing specific, Paul.
No, okay. All right, I think that's probably where we might end that discussion, Jock, and hand back to you.
Very good, thanks, Paul. And
I think we've lost Jock.
Yeah.
There's a certain irony in the tech presentation.
Session. Could
Sorry,
somebody?
Jock, we lost you there for a moment.
Hang on.
You're back.
Can you hear me? Right.
We can.
Right. Sorry. Okay.
All right.
We're in good shape. So so thank you very much, Paul and Vishwanath, for that update. You've covered a lot of material. We should, Paul, just briefly deal with the two other issues around the multilateral instrument, the impact of that, and I'm happy to deal briefly with that. And then there's the other ruling or whatever, and then we'll open it up we've got some really good questions that we'll go through. So look, we touched on the multilateral instrument in Australia. It's modified the Australia-India double tax treaty. In Australia, that's effective from 1 January 2020, and in India, generally from 1 October 2019. So it's up and running. We're certainly seeing a lot of thought. The ATO is certainly looking at different aspects of this overlay, as we've seen in our audits, not just with other international business, not just including India or Australia. The main sort of highlights, I guess, in terms of the treaty are the widening of the concept of permanent establishment, most particularly the aggregation rule, where contracts might be perceived to be split, and narrowing the carve out for preparatory and auxiliary activities. There's also more specific process around the mutual agreement procedure, but the big one probably to watch is the principal purpose test and treaty benefits, all right, which is not what we're mainly focused on today, but it certainly is an issue where, for example, under the treaty of withholding tax is limited to 15% or whatever as a royalty, rather than 30%, which is our domestic rate. So that's probably enough on that. If we could just move to the next slide, and back to you, Paul, just to talk briefly about this other guidance.
Sure, Jock. Thank you for that. The practical compliance guideline isn't directly associated with the royalty question, but it's incredibly important for companies in this sector because in the end, most of the value within them is often tied up with intangible assets. And as a group, many of the things that you might do with those intangible assets have quite complex tax consequences. And it's probably most commonly encountered in situations where a group acquires another business and then absorbs the new business into their own structure and may or may not deal with the intellectual property assets in the process. So you buy another into your own code base, the code's shifted, effectively an intangible asset is moved from one country to another. What this practical compliance guideline very heavily focuses on is situations where dealings occur in intangible assets, assets which are covered by copyright, patent, trademark, and also the consequences of actually managing and operating those assets from time to time. It is actually quite a useful document because it's broken into a couple of parts. What it does is it sets out the fact pattern by way of an example, and then it talks about how the tax office will think about that when it looks at it. So this is a practical compliance guideline, not a ruling. This is actually an internal document for the tax office that the commissioner uses to decide when to allocate audit resources to a particular matter they're looking at. As a result, it looks at the transaction and it says, here are the following 4 aspects of this transaction which we think mean that we should allocate resources to it, because there's a risk that the revenue outcome's not the correct one. Incredibly useful for taxpayers though, because it very much tells you the probability that your transaction will attract significant attention. So as I say, main category, dealings, movements, cross-border, acquisitions, disposals of any business and its intangible assets in this sort of sector. That's quite a lot of the value. But it also talks about, for groups that are operating currently, and who have a view about where their intellectual property is located, how it's managed, how it's operated, and the transfer pricing outcomes they should be getting out of that. This is a document that talks about what the Commissioner looks for in order to decide whether the filing positions are correct. Do you have the proper resources to manage intellectual property in the jurisdiction where you say it's located, and the tax consequences that follow from that. So quite a lot of practical information in a very detailed form, but not a binding ruling for taxpayers, a internal practical guidance. I think the major issues that have been raised, and this is draft as well, the major issues that have been raised in response to this draft have been issues around the question of it's a very complex matrix of facts, and if there are 8 different factors involved, and you tick the Commissioner's box on a couple of them, but not all of them, how do you make sense of whether you should be audited or not? Does it matter how much money's tied up in the transaction? Does it matter which jurisdictions are involved? So on the face of it at the moment, the way it's written, you really only have to tick one box and you're high risk and you get a complex audit outcome. I think industry generally feels that it should be a more nuanced package, or almost a traffic light assessment that lets the Commissioner's staff figure out on balance how this works. Also a bit of a question around wanting to make sure that, that if you don't, if you tick some of the boxes, that it doesn't automatically lead an audit team to conclude that you're an at-fault taxpayer, because many of these requirements are not things that taxpayers would ordinarily do in the course of business. They're things that make good sense in dealing with the tax authority, and it's sensible for the Commissioner to ask whether they're there or not, but the fact that you haven't got them shouldn't automatically lead to a penalty outcome. So very large document, quite complex, but that's the best I can do as a brief summary, Jock.
That's terrific, Paul. Hopefully I'm back on off mute. Hopefully everybody can hear me. So look, we'll move, if we could move to the next slide. Thank you, Paul and Vishwanath. We've received various questions, and in no particular order of priority, perhaps one for you both initially. Is it more about the technical aspects? For example, Vishwanath, you mentioned customisation type, contracts or aspects of contracts, or the lack of certainty, for example, around apportionment that you have concerns, or is it both that you're concerned?
So I think, Jock, I think it could be both. As mentioned, in a typical customization situation, the type of activity, what will be rendered over now, I think it has changed, right? So how do I forcibly fit into the 9 category is going to be a challenge, and whether it would also fit into the new ruling. So either I would decide that, no, I want to ensure that I fit within the Tech Mahindra decision, which is upheld by the highest court in Australia, and I should not deviate from there, so that I am good as far as the litigation is concerned. Or I should think that, no, there are some activities which did not get covered by the Tech Mahindra decision. Then what do I do? Then I will look at the ruling, whether ruling helps me into fitting into any of those parts. So I think that's where the call will have to be taken by each of the industry to see how do I really defend this for the type of service which is typically not covered in the decision or in the ruling. That's where the difficulties are going to be. Yeah.
Understood. And Paul?
Yeah, Jock, the reason I keep harping on about apportionment is in practice, most of the really, you can end up with the parties getting a broad agreement on what the technical issues are. It might take a while. Typically, it'll involve quite a lot of work between them and some legal analysis. But in practice, I find the thing that the parties actually have real practical trouble resolving is just the apportionment problem. Because as Vishwanath said, this stuff isn't science. You're relying on sometimes on an opinion from an expert or one of the contract team. It's not often the case that the actual timesheet records even can be used to simply and easily apportion value across parts of a contract. I think in practice there's an enormous amount of dispute tied up in just the practical question of what's the right value to attribute to an element.
Thank you, Babe. And so the next question: do each of you believe there is much of a risk that the ATO position, for example, reflected in example 5 around, cloud services, could be replicated, more widely around the globe? And if so, do you, and bearing in mind, Paul, you've emphasised the OECD guidance and substance over the form. What are your thoughts on all of that?
I think the tax office is an extremely helpful global player, and views it as an important responsibility that the rest of the world understands their views very clearly. So I think many taxpayers, and Vishwanath, it'd be interesting to hear your thoughts. I think many taxpayers observe that problems they first encounter in Australia have a way of popping up elsewhere in the world later. I think it's a pretty tight-knit community. They share a lot of information. That's the global tax authority community. And I think the tax office is extremely active in the global environment in sharing information. I think that subcontracting cloud one is really interesting, though, because back to the substance over form thing, what if that contract is not between the Australian subsidiary and the end customer, but is purely between the end customer and the offshore parent? That's an example that to me is extremely factually dependent. And in fact, quite a lot of business models actually have a different structure, which don't seem to raise the same problem. So that's a bit of a substance over form thing, I think, as well.
Thank you. Vishwanath, any thoughts?
No, I think in a typical situation like this, I think, I don't know whether the location of this server is going to be an important criteria to determine where the service is provided or where the royalty should arise. Because many of the times it happens that in a typical cloud computing situation or a cloud, it could be up in the air, right? An Amazon cloud or anything. Suppose if they say the entire control is in Singapore, but a service provider is in India and the service recipient is in Australia, then whether it would still fall into the definition of royalty or not. I mean, I don't know. I mean, I don't think that has got ever tested. Now, these are some difficult situations, and as you rightly mentioned, these are global service providers. I mean, most of the IT companies are global service providers. A server could be kept at one of the locations, but we don't know who the final recipient is and how the taxability can be determined. So I don't have an answer today here.
Thank you very much. Look, the next question is probably more for you, Vishwanath. You're in close contact with various other Indian-based IT companies. What are they doing and how are they responding to this draft Australian tax ruling? I think you've had some recent meetings as a group. Could you just elaborate on what the status might be there and what you plan?
So I think we have grouped together, not specifically to this ruling, though the rulings have been forwarded to NASSCOM. NASSCOM is a body in India which is regulating most of the IT companies, and they are quite active in taking up the information technology issues with the counterparts in various countries. There was scheduled to be some discussion around this in the coming days, but I'm not too sure if 23rd, tomorrow is the last day for this feedback to go through. I'm not too sure whether the Indian NASSCOM body would be able to give any feedback on that, because we haven't had a discussion around this particular point, to be very honest. And especially because of the COVID situation, I think we are not able to. I think probably a suggestion through this particular panel, I mean, through this particular association is this particular date should need to be extended at least by a month for the Australian government to come out with some valid proposition. And I think Indian companies are the ones who are going to be impacted. So my suggestion, I think, to Satyarth also is it's possible to put across that the date has to be extended. It can't be 23rd.
Thank you very much. And look, that's a great segue into the next question, a fairly obvious question, more for Paul. What do you expect in terms of the ongoing consultation process, and when do you think a final ruling may be issued? You've been involved for a long while. You're involved in 93-12 as well, and followed the evolution of this draft ruling very, very closely. Paul, over to you.
I'm horrified you're handing out my age that way. I think I think 93-12 was actually a well-written document that built on a lot of input from industry and the profession. I think if you look at the development of the stages that the new draft has already gone through, it is clearly the case that many of the inputs have been taken into account and have been adopted by the Commissioner. So I think the consultation process works. I think a number of really good points made by the profession and industry have already been picked up and folded in. The fact that it's a ruling, the original intention back in 2018 was to do something less than a ruling, which would have given taxpayers less comfort. So the status changed, the effective date changed. They're very important things. So I think the consultation process with the tax office works. It's important to be engaged. If you're not in it, you can't win it. So I strongly advocate people who've got a view to put it forward. And I expect we may see some further changes as it comes from draft into final.
Very good, thank you. I just need to lean over to read this next question a little bit more closely. This new ruling talks more about the standardised softwares which can be copied, distributed, etc. However, this does not address the scenarios where the overseas vendor is more of a service provider nature versus know-how provider, because such vendor does not provide anything which is readily available, but constructs as per the need of the customer in a tailored arrangements. I suspect that's what it's leading to. What will happen for these types of cases?
You want me to respond to that one, Jock?
Please.
So I think that question very neatly ties together Tech Mahindra and the draft, because I think what we see in Tech Mahindra in the first federal court decision is a very good framework for analysing contracts of that sort. And then what we see with the draft is, as you say, subject matter is slightly different, but we see some new principles emerge. So what the new principles tell us is that the Tech Mahindra analysis still works. Those definitions haven't changed. If you have contracts that have those types of services or those types of frameworks, you've got a way to figure out how they're going to be analysed. And what the draft tells you is that there are, however, a couple of new twists you have to put into that. You also have to consider all of the contractual elements down the chain at the customer level and feed that thought process back into the classic Tech Mahindra analysis. So you're quite right. The ruling doesn't instance decision in Tech Mahindra does deal with that and quite well, and in a way that gives you principles to apply to new business models.
Very good. And another shorter question, thankfully. How will these issues change with increased migration to cloud, if any? For either or both of you.
Don't we hand that back to you as a pillar one, pillar two question, Jock? I think some of these tests, to me, the draft, so Australia is short of cash. We'll do what we can to extend the net. The concept of royalty, you can't hugely expand it, but you can analyse it more thoroughly and gradually increase your royalty tax take. However, business models are still going to be outside the reach of this draft ruling. A moment ago I talked about, what happens with the cloud situation if the facts change and the contract goes straight offshore. You've still got to worry about DPT and MAL and so on, but that looks like a model that example. No, it's a simple example. On one, the royalty ruling works; on the other, it doesn't. So that's silly. But I think the answer is that the OECD's processes around Pillar 1, Pillar 2 are designed to try and provide a framework for a quite different basis of tax allocation between jurisdictions that gets away from the mechanical operation of the royalty rules. So I think, that watching how that unfolds is probably going to tell us more about the evolution of this subject.
Thank you, Paul. Vishwanath?
So I think, I think as I mentioned in the earlier also, digitalization or the type of service, what is going to be done, what is trying to be captured through this Pillar 1, Pillar 2 category. I'm not too sure whether it's easy to really, capture these type of services to say that this would form part of royalty. I think, as I think Paul rightly mentioned, probably the principles, if they are laid down through the OECD, probably you may have to replicate these type of things in Australia. That could be a better situation than having its own rules on the type of services what is going to evolve in future. Yeah.
Very good. And look, we're probably heading towards, if not the final question, close to. And we did talk about this a little bit amongst ourselves. What do you each believe are the prospects for a revision of the Australia-India Treaty to deal in part with some of the issues that have been, a labour of love, Vishwanath, for several years for you? Maybe if you go first, and we all respect the diplomatic side of it. But if you had your way, what would you see? And also, given that Australia certainly has a priority to modify some of its treaties, particularly with major investment and trade partners, and India is clearly one of the highest priorities in that regard.
So I think post this decision, I think many of the companies have gone into a MAP situation. That was one way to resolve it, but what we have been facing is there is no positive response from the Australia side because of the negative decision for the companies in Australia. So the MAP doesn't work. The second is there is a discussion around amending Article 23, especially in a situation where, suppose if there is a type of service which is being rendered, a treaty should override the domestic law. That's something what is internationally accepted, and whichever is beneficial is something should be considered. But I think it is still in the discussion stage. What I hear is the Indian government has provided that particular suggestion to the Australian counterpart, but I'm not too sure whether the Indian government has received any feedback on that amendment of the treaty per se, especially the Article 23. So that's what it is as of now. I'm not too sure whether anything further has happened, because this update what I have was probably 4 or 5 months back.
Thank you very much. And Paul,
I don't have any better gossip on that, Jock. I think this is one of those situations where the particular provisions in the treaty were each put in for their own good reason, but there's a sense that the final outcome is not what everybody was expecting, and that's that's a pretty subtle set of changes you're going to have to put through. The extension of the services definition in royalty, I think, is traditionally an approach that India has preferred in treaties. Certainly, it's unique in Australia's treaties, pretty much, we think, at the Indian insistence. But it's the combination of that with the other provisions that's produced a sort of an overall outcome that is, most people think, inconsistent with how the treaty should work. As Vishwanath says, there should be mechanisms there to reconcile those two definitions that don't exist. So I think it's actually quite a complicated amendment.
Thanks, Paul. Very good. Look, we've probably got room for one more very quickly. Vishwanath, you mentioned earlier some of the emerging business models, and including business process outsourcing and, various others that you know much more about than what's happening at the cutting edge there. Are there some of those or any of those that you're looking to, it should be covered in the ruling in more detail? You've mentioned things around apportionment, but is there anything else that you'd like in terms of business models covered in the ruling?
So I think I'm not too sure. I mean, so whether we haven't got any questions from the Australian government that what's the type of model each of the IT industry really engages with the Australian customer. I'm not too sure where the inputs have been taken to come to this ruling situation, because we at Tech Mahindra have not seen that we have received, unless I'm missing this point here. The second, as I mentioned, is typically a cloud computing. Though it's covered briefly in that. What happens to a typical software package? Though it is mentioned that it is not taxable, it's not in the nature of a royalty. What about the business process outsourcing, call centers, or the type of services, which I'm not too sure whether it is all captured, all the type of services. So that's where I think we need to have more clarity. And if at all the Australian government has not taken an inputs, the suggestion is they should seek inputs from the various IT industry who have been rendering the type of service in India or any other country and Australia. That could be, because I think it's evolving. So as I mentioned, we typically are the finance guys. So the guys who really deal with the customer are the ones who will go into the specifics of the type of service, what they really render to the customer. And we could be taken by surprise after 3 years, because we as a tax guy or a finance guy may not be even aware that my delivery guy, my counterpart, has already done something which may not have, which may actually fall into a royalty situation. We don't know.
Thank you very much, Vishwanath. And Paul, before I hand over back to Satyath to close the session and do a vote of thanks, is there anything else that either of you would like to mention or raise? It's been a terrific session. We really appreciate it. But for either of you, maybe Paul first.
Not from me, Jock. No, I think we've covered the ground.
Thank you. Thank you, Paul. And Vishwanath?
No, nothing. I think it was a great session. And I think it's a pleasure to be part of this panel. And I think that something was really great. Yeah.
Thank you both. Over to you, Satyath. Much appreciated.
Thank you. And what an insightful and factual discourse this was. May I even submit that this was one of the most intricate issues that AIBC has been able to host. I just doff my hat to all the subject matter experts. Paul, it's probably still very early for you. Thank you for those insights. And as an understudy, look, what I gleaned from all of you experts is the fact that ATO is a very progressive, active player on the world scene. This is a rapidly evolving subject. Again, being involved in the sector myself, I do think this requires a lot of dissertation, a lot of deliberation, a lot of discussion in the era of cloudification, digital transformation. Also, given the afflictions of COVID that we are all getting used to now. So that was a lot to take in, but it was very insightful. So Paul, thank you. Jock, thank you. Vishwanath, you are a true global practitioner. Your insights, I'm sure, will be taken on board. You were incisive as always. I've had the pleasure of working with you. And I think what you offered today was a very practical flavor to how the policy and the treaty should evolve. Again, this is a very rapidly evolving landscape. So this is a very critical discussion for all of us. May I now also thank the two fine ladies, actually three of them, I beg your pardon. Wendy, our Secretariat lead from AIBC, and Sanjana. May I also, and also Gitanjali Bajaj, I beg your pardon again. Now, we were able to execute this event within days, and that's not happened. That's not happened before. And to address such a complex issue and get all of you subject matter experts, I have to thank DLA Piper and Sanjana for taking the lead to get in touch with Wendy, and it's been brilliant. I would also like to thank who is a very vital cog in the wheel, the executioner, as I call him, Vishal, who makes things happen every time. He puts it all together, and we are able to speak to a wider audience even in these times. Last and not the least, the audience. You were provocative, you were engaged, and your questions were very welcome. I'm just looking at my notes because I made some copious notes today, trying to understand and get my head around it as well. But yes, all in all, thank you all. Thank you for joining. Thank you for your active interest. And it's a pleasure at AIBC to promote and foster such a discourse. And as a co-host to Jock, I just reiterate my gratitude to everyone for the event.
Thank you.
Thank you, Siddharth.
Thank you.